And as Ms. Hesbrook said, you can see that the session that you're in or the hearing that you're in is being recorded because you'll see it on the upper left if you're on a laptop. I'm not exactly sure where it will be if you are on the iPhone or an iPad, but on a laptop, you'll see it on your upper left of the black screen. So with that, let's go ahead and get started just so I leave enough time for questions and answers. So we're on Zoom. That's where we find ourselves. There are free accounts, there are paid accounts. To the attorneys and to your respective clients who opt to get a free account in lieu of a paid subscription, please rest assured that you can participate in the hearing even if you have the free account, and it won't be time limited to the 40 minutes or 45 minutes per session that is advertised on the free account. And that is because all of the judges in Texas have been given a premium account. And when we host the hearings, when we host the meetings and send you the invitation, you are on our account, on our time, and you won't, hi, how are you, Laura? And you will not be penalized for that. So if that gives you any assurance, or if that gives your clients any assurance, please know that. With regards to the chat feature, I wanted to just show everyone at the bottom on the 3 dots, you'll see the chat feature. And so this is a chat. It's basically a communication tool that you can use with everyone or that you can use privately. Privately, you can use that to slip notes to your client or to slip notes to opposing counsel. Do not private message the judge. I think as we go forward with the hearings on this, you'll have some admonishments that are created by different judges. So please know that private messaging the judge is the equivalent of an ex parte. Also be mindful, especially when we're going to be juggling a lot of things during your first few Zoom hearings, courts included, to pay attention if you're going to use the chat function and you're intending a private message and you hit the wrong person or you select everyone instead of a private message, there's no way really to get that back. So if you type out a private message but you don't select private or you don't direct it to the right person, maybe it's a message that you intended to have to your client, but the last person you private messaged was opposing counsel and the message goes to opposing counsel, there's no real way to capture it back. So just be very mindful when you use the chat function that once you type it and hit return, it's out there. So message to everyone or message to private, just be careful with that. A little bit of hopefully comfort with the chat function. It's not part of the official record. It's not going to get recorded. It's not going to be saved. And as the host of the meeting, we don't have the ability to see private messages. So don't worry about whether or not the judge is going to be able to read your private message, either between you and opposing counsel, or you and a witness, or you or your client. We can't see the private messages. And thank you for the question, Ms. Wingate Hernandez. So I had previously shared my screen as we were getting started, and I can do that now. So let me share my screen for those of you who aren't familiar with that function. At the bottom, if you're on a laptop, at the bottom of your screen, you'll see a green button. And if it sounds like I'm trying to talk too fast, I really just want to cover as much material as I can. Judge Diaz has just joined us, so welcome. So the green button is a share screen tool, and you're able to select what you share. So I have a Zoom question and answer outline that I was sharing. And I think someone tried to come into the meeting as I was moving over. So let me stop this share real quick and let in the other person. Okay.
Judge, when someone tries to come in, do you have to let them in? It's not automatic?
I have selected my setting, my meetings to where I have to give them permission to come in. It's not automatic. I've done that for a number of reasons. I might change that in a week or two because it is a juggle. But for purposes of maintaining, for me, decorum and control over the courtroom and the hearing, I've selected that people can join the meeting and they're put in the waiting room until I admit them.
Thanks.
So that's that. So let me get back to the share screen. So this is just the outline that I wanted to cover. The chat feature between everyone and private. The private chats are supposed to be slipping the notes to your clients. Do not private message the judge again. There are going to be admonishments, I suspect, by different courts not to private message witnesses while they're testifying, or not to, you know, interfere with someone's testimony by trying to private message them, etc. So please be mindful of that as well, and make sure that you appreciate whatever admonishments come from your court. The waiting rooms, we talked a little bit about that. Oh, I do want to cover this. Do not use the chat to say something that you would otherwise say on the record. So for example, if there's a opposing counsel that's questioning your witness or another witness and they make a wrong reference to an exhibit, for example, they identify it as defendants 2 when it had been previously marked and admitted as petitioners 2, go ahead and make that correction on the record. I know myself, I'm hesitant to interrupt people, especially in this forum, but make sure that you're not using the chat as an alternative for speaking on the record, because the chat is not part of the record. So if you need to clarify something on the record, or if you need to correct something that was stated by opposing counsel for the record purposes, please do that. The chat is not part of the record, and I wouldn't rely on your opposing counsel or even the court to make the correction that you included in the chat and make that on the record on your behalf. As you can see, there is a lot to manage, and so sometimes things come through the chat and they're just not read. So if it's important enough to state it on the record, go ahead and interrupt and make sure you state it on the record. Waiting rooms, we talked about that. Again, different people are going to have different judges are going to have different ways of using that. For now, all of my meetings are going to begin with everyone going to the waiting room and then being admitted into the courtroom, if you will. Breakout rooms, that's an opportunity if you need to confer with your client, if you want to confer with opposing counsel, outside the presence of the court, outside the presence of your clients. A breakout room can be created and you can be put to that breakout room. You can be brought back by the judge, by the host of the meeting. Different judges have different practices regarding the breakout rooms. I know Judge Ferguson has indicated that his practice is to never enter into a breakout room. I have not yet adopted that as mine. Let me get to a question here from Ms. Gutierrez. When judges are sharing documents such as the outline, so if I were to share this into the chat, which I'll try to do right now, you could download it from the chat. I don't think you can download it from a share screen function. I don't know, Judge Alvarado, Judge Diaz, Judge Flores, do y'all know?
I do not.
So here.
On a Mac computer, if you do Control-Shift-4, you can take a screenshot of the area of the screen that you want. Actually, not Control, it's the Apple key, Apple Shift-4, and then it'll bring up a little crosshatch and you can point and then drag and select what part of the screen you want to save.
And I may have misunderstood the question. Is the question, how do you save what someone is sharing from their screen?
Yes, I think that was the,
Yeah, like, because it's different, because she put it on the screen versus putting it on the conversation where it says upload a file.
Right.
I was trying to figure out, let's say the judges are gonna be showing a document or something else they want us to look at, and later on we wanna remember anything about the hearing, and we're gonna have the capability of having the on-screen share.
There is another feature for you to save what someone is sharing on the screen. I'm trying to pull it up. I'm using my phone right now, but I know when you're using your computer and someone shares a screen, there is there's a drop down arrow at the top right that says something like view options. And if you drop that down, I think one of the options is annotate. If someone doesn't turn off the annotate feature, then there's a little save, like a disk, I think, that you can click on to save, and it will save a screenshot of not just what's being shared, but also if you have the participants on the right-hand side. So I think what the other function, it makes more sense if you can learn how to just screenshot on your computer, whether it's a Mac or something else, and Google how to do that. It's easy. That may make more sense because the function I'm referring to is dependent upon the person's settings that is sharing the screen. So if they have annotation on, you should be able to go to the drop-down menu at the top, annotate, and you can save what you see on the screen.
Now, can I add something to that point? So you don't know if somebody is saving that, do you? So Judge Alvarez, by way of example, I followed Judge Diaz's instructions just now, and I was able to save what you have on the screen. Did you receive a notification on your end that I saved that screen?
no, it didn't. No.
And so that may be problematic, because if you have spectators in the room, that could be a potential problem, because you will not know if they have saved that screen that you're showing. Another point I'd like to bring out is earlier, Judge Alvarez had shared her Zoom question and answer in the chat feed. And anybody that's in the room can download that. So if you have, again, a spectator and you're sharing an exhibit through that chat feed, there's a possibility that somebody in that room could download it and you wouldn't even know it. Judge Alvarez, have you received any notifications in your chat since you have uploaded that Zoom question and answer outline to chat that anybody has downloaded it?
No.
Okay,
And I don't think you can.
I see that Maribel, she was able to download it and save it into her folder. So again, those are things that you need to be aware of, because we have this open courts doctrine that we have to deal with. If I could make a suggestion about sharing documents, and I talked to Judge Alvarez about this earlier, and I don't mean to overtake.
No, please do. I think the more
Answer.
information, the better.
I am setting up Google Share Drive for the 438, and when I get the assignment out of presiding court, I'm going to be creating a folder in that shared drive with the case cause number and the style. And in that share folder, I'm going to create 4 subfolders, 2 for each side if it's a two-party opposition. And in that folder, I'm going to have one that's designated exhibits and one that's designated pleadings. And that main folder I'm going to be sharing with the lawyers and or unrepresented litigants, so they can upload their exhibits into the respective exhibits folder, and then they can upload their pleadings into the respective pleadings folder. So you don't necessarily have to publish them to the court in this fashion here with a screen share. Once you have walked your witnesses through proving up the document, or if you're stipulating to have them admitted by agreement, the court can actually pull them up in the Google Drive and look at them and publish them to the screen without actually having to do the share screen function here. So that may be a safer alternative if you're trying to keep certain records from being captured or screenshotted or downloaded by people you're not wanting to have that information. Obviously, when you're sitting in a courtroom and they're up on the big screen, everybody has access to them. But you know also that they're not going to be walking away with a complete copy of someone's tax return, even if it is redacted. You know, because they just don't have access to that in a spectator setting in a regular courtroom. However, in this environment, it's a little bit different. So those are things that you need to be very cautious about as we're starting this process. And that's my 2 cents.
I had muted myself. Thank you, Judge Alvarado, because I think the more we share and the more we practice and the more we know about the features, the limitations, and the scope of the features, the better off our hearings are going to be. And I do want to just make sure that everyone's aware different courts are going to find different ways of complying with the open records, the constitutional open courts. In Texas, I know some folks aren't letting everybody come into their Zoom hearing. They're just streaming the hearing via YouTube. They're not controlling who's watching or who's not watching, but they're also not having spectators actually in the hearing. I'm not sure which way is going to be the better practice. I know that I am leery of streaming, even streaming to YouTube and deleting later. I'm still not comfortable doing that. So I have opted, as I think Judge Alvarado and Judge Diaz have opted, to publish the meeting, the hearing email and invitation. And so if people want to come in, they're actually going to be with us just the way we are. And if you've got the gallery view on your screen, you see that we've gone from the 8 participants that we started with to 32 participants. And so that may be what happens in your hearing. You may get started with 4 participants, yourself, opposing counsel, and your respective clients, and then we've got to manage who's coming in if it grows to 8 participants or 12 or 16. So it's just something that we're going to be working through together. So going down the outline, I wanted to talk about the breakout rooms we did. I also want to talk about the video placement. You can see, okay, so see, I've got a private question on the chat from Mr. Garza. The question is, will judges have access to and be able to see all current case filings at the time of the hearing? That is a very good question. And we were, is that Judge Diaz?
No.
Oh. And so I'm sorry to stop, but this is something that we were talking about earlier, and it's helpful to see the demonstration. When you share your screen, other participants in the hearing have the ability, by going up to the middle, to annotate what you're sharing. So the little heart, the little stars, if that is one of your exhibits and that is something that you're planning to capture and then save as an exhibit 2F or 2D or whatever the case may be, appreciate that you may have someone trying to write on your screen share, either inadvertently or purposely. So be aware of that. And then going back to the question regarding whether or not the remote hearings are going to have access to the live pleadings, I'm going to be asking the attorneys who are assigned to me to be ready to share the live pleadings with me via email or via Dropbox if I can get it set up the way Judge Alvarado has it set up. So I know the technology learning curve is steep. It's steep for me. But when you come to court, make sure that you've got the live pleadings ready to be emailed or distributed to the court that's going to be hearing your case remotely, as well as your exhibits. So thank you for that question.
Judge Alvarez, may I, on the heart and stamp issue? Oh, there we go.
Yeah.
So this Zoom bombing that we're doing, that heart that I drew on there, you can actually prevent that. It's, it could be a benefit to you if you wanted to use it during your presentation, but the disadvantage is that anyone else can draw on it. You can disable the feature before you share your screen, it gives you the options of allowing participants to annotate on your screen or not. So you'll want to make sure that you select that they not be able to annotate on the screen unless you're sure there's no one else in the room and you want to use it for yourself to annotate for the court. I would suggest turning that feature off.
And that, thank you. So I'm going to try to do that. When I go to share screen, Judge Diaz, where is the, it's advanced sharing options, is that correct?
I believe so. Yeah, I'm on my phone, so I can't tell you exactly, but I believe that's correct. Let me try to pull it up on my computer.
Let's see. Because under advanced sharing options, I've got how many participants can share at a time, and I've selected one participant can share at a time.
Well, it's different for you because you're the host.
Oh,
So
okay.
you're going to have different options. This is for just people that are participating should be able to turn off the annotation feature. Let me try to pull it up on my computer, and I'll send instructions in the chat so that we can continue.
Okay, thank you. So moving on to the video placement, and is it okay that we're not sharing the screen, or would you rather have the screen shared so you can see the outline? Anyone? Okay.
I like looking at everyone.
Okay, yeah, no, and that's helpful too, right? To take a look at everyone in the gallery. Okay, so I won't share it, and we can see everyone. So the video placement, when you're talking to your witnesses, and even when you're talking or thinking about it on your own, with the hearing presentation, you know, things that we haven't thought about in the courtroom, we have to think about virtually. So the lighting of where you're at, the lighting of where your client is at, what is in the room, distractions, what it looks like in the back. We've seen during the virtual hearings that, oh, I'm so sorry. We're letting in a few more people. So we've seen that that's where your witness is testifying from, and whether or not they're using a virtual background or not, or if they're hiding their hands, hiding their lap, etc. That is a new line of questioning that you may want to adopt, or that you may want to prepare your client for. So just know that the virtual courtroom, as much as we're trying to replicate the in-person courtroom, it does have some new considerations and new questions to review and to prepare for, both yourself and your client. And that takes us to the practice. Make sure that they know to sign up for Zoom, your clients and yourself, to sign up for Zoom with your real name, your first and last name, to where you can be identified. If you're going to have witnesses testifying, if you're going to have witnesses that are going to be participating, please make sure that they sign up and they come into the hearing room with a first and last name so they can be identified. You may not be able to see this, but as the host of the meeting, the courts are now trying to manage everyone that's in the hearing room, as well as make sure that everyone's identified and that the rule is being followed if there are witnesses to be excluded. So as attorneys, adopt some of that as well. Help manage some of that. If you see that a witness was inadvertently led into the hearing room that shouldn't have been, don't be shy about interrupting the court or stating on the record, I believe so-and-so is in the hearing room, may or may not be willfully violating the rule, but just bring it to the court's attention, because there is a lot going on virtually that we are doing. And so your eyes would be helpful to make sure that we see that. Going through, I want to get through 2 exhibits, the prepping of your client and the background noises and that sort of thing. That's on the outline. If you've downloaded it from the chat, you've got it, and you could probably go through that. I want to be mindful of your time and make sure that we leave room for questions and idea exchanges. So exhibits, Judge Alvarado introduced a way that she's going to be collecting the exhibits before the hearing. different courts are going to have different ways, whether it's Dropbox or email or Google Drive, and everybody will probably be changing just a little bit as we adopt best practices from each other and from other courts around the state. So please be as flexible as you can. And I see that Judge Diaz has put the instructions for turning off the annotation settings when you're sharing exhibits via your screen. So capture that, or you know, copy and paste it, so that way you'll have it.
Judge Alvarez, I don't think you can copy and paste from the chat. I tried to do that earlier today and it didn't work.
Did you see? I was just about to try that, but thank you for telling me. So everyone read it and memorize it. No, I'm just kidding.
She added the link.
The link. Oh, wonderful. Thank you, Judge Diaz.
You're welcome. That's a link that explains the annotation feature for those of you that want to use it or want to turn it off. If you just scroll down near the bottom, you'll see where it says annotation settings, and that it has the part that I copy pasted there that explains how to turn it off.
And definitely will be helpful when you're going to be sharing exhibits. And I think something that was shared, I think it was by Judge Ferguson, it may have been by Judge Miskell or Judge Varial. When you're referring to the exhibits, even if you've provided them to the court, if you become familiar enough with the share screen function and you can actually share the relevant portion of the exhibits that you're referring to in your argument or in your questioning, that presentation is going to be a lot smoother than if you just keep with the argument or keep with the questions and want the judge to be on the, you know, on the side of the screen pulling up the Dropbox exhibit or pulling up the attached exhibit. So as you're working through your presentation skills and your trial skills using this Zoom tool, the more proficient I think you can be with the share screen function and sharing exhibits as you're presenting them or as you're questioning witnesses, I think that will be really effective. So it just makes for a smoother presentation. We've had the opportunity to see some of the mock trials where attorneys have become more proficient at sharing screens than others. And it definitely makes a difference when you're able to, for example, share the PowerPoint on your opening statement or share an exhibit that you're questioning a witness from, whether it's a direct examination or a cross-examination. So if there's something to be taken away, and I've got to share screen and do more practice myself, but that is a really helpful tool to help with your presentation during the examination and during your argument. So I've also included some sample Zoom admonishments, different things that courts may ask, what is permitted to have in your witness's hand, in your client's hand, whether or not you're going to be asked to pull things up, whether or not your witness is going to try to refresh their recollection on their own with a phone or with an iPad and not alert the court or alert you that they're going to do that, you may want to have those conversations ahead of time, because I think some courts are going to be pretty explicit regarding what can and can't be done during the Zoom hearings in an effort to try to make sure that everybody is abiding by the rules. Miscellaneous things to cover. If you've got, we appreciate that there's a lot of opportunity to confer with opposing counsel given this presentation style, right? Obviously, the more agreed to exhibits that y'all can reach before the hearing, the better. If there needs to be a pretrial conference, if there has to be a pretrial conference, excuse me, regarding exhibits, make sure you let the court know that ahead of time. So that way, maybe we do a 5, 10, 15-minute pretrial hearing before the temporary orders hearing and that will make the presentation smoother. Maybe it'll alleviate some question about what you can introduce in opening statements, or how much foundation or setup you have to do with your witness if there is no agreement and there is no favorable ruling ahead of the trial. So I think we're going to see some exhibits that are going to need some pretrial litigation virtually that may have been relatively smooth or easy in person. So just be prepared for that. Again, as much as you can, confer with opposing counsel and streamline any objections to the exhibits that you can, so you can make sure you take into consideration that when you make your time announcement in presiding court as well, because if you're going to have a 15-minute fight over, I don't know, a tax return, whether it's a tax return for an individual or a tax return for an alleged community corporation, and you're only announcing 30 minutes on a temporary orders hearing for support, take it into consideration if half of that time announcement is going to be on pretrial just on one exhibit. So just be mindful of that. Let me see. Other things regarding Zoom, you see some folks have profile pictures and some people have just their names when their video's not on. Know that, explain that to your clients, whatever they opt to do, just so they know that that's an option. Raising of hands, it may be hard to manage during the hearing, but there is a feature where you can raise your hand if you have a question to ask. And that is on the participants. If you go to your participant screen and you go all the way down, you'll find it. Although now I said that and I can't find that.
It's under reactions.
Reactions. Oh no, so the reactions that I have are the clap and the thumbs up. So I don't know where it went. Judge Alvarado, Judge Diaz, do you know where the raising hand is?
Judge Alvarez, I had this issue as the host as well. I didn't see it as an option for me as the host. I think it's just participants.
Can you put your...
We can see it under participants with the drop down.
Okay,
You see the
good.
raising hand option? Yeah.
Yeah, over on the right-hand side, it pops up with underneath the participants.
Okay, perfect. Thank you, Ms. Marvel, and thank you, Judge Diaz. Yes, I forgot that as a host, we can't raise our hands because we are moderating the meeting. The other thing to know is, okay, share screens. Crystal Thompson, on the training that she did with Judge Miskell and Judge Ferguson, indicated that there was a better functionality when you share PDFs as opposed to sharing Word documents. I don't exactly understand why, but I can tell you that it's easier for me to share a screen with the PDF, and I feel that it captures it better as opposed to doing the Word document. I don't know why, but I just wanted to share that because that's what I heard and that's what I experienced myself. Random tech issues. So something that Judge Miskell shared is that during one of her remote hearings, she actually was disconnected from her internet. Something haywire just happened and she, as the host, left the meeting. And folks kind of just wondered a little bit. And of course she got word to her clerk that she would be right back, and she got right back on. So I just bring that up as a talking point, as a bullet point, that tech issues may happen. Your screen may freeze, you may get disconnected, your client may get disconnected, and that's okay. Just get back on and we'll continue as best we can. I think you're gonna see from the bench and from each other a lot of patience as everybody tries to get up the learning curve. And a lot of grace. So just replicate that and share that. There are going to be some things that happen that we're going to have to be accommodating on the fly. So appreciate that and know that the bench appreciates that as well. So I'm going to open it up to questions or comments. Anyone? Ms. Rojas? I'm trying to unmute you. Okay, there you go.
Okay, can you hear me okay?
Yes, ma'am.
Okay, I have a question. How will I show my witness or a witness a document without showing the judge before it's authenticated? How can I do that?
Can I answer that, Judge? So Ida, what I've been doing, like I said, is I've been setting up that Google Drive. And so I don't necessarily have a problem giving a witness access to a specific document if you ask for it in there. Or you can share it with them ahead of time and just make sure that you're representing to the court that that's the same document that you've emailed your client and they're looking at right now that's sitting in the Google Drive. I don't look at what's in that Google Drive unless it is published to the court. And at that time, once it's been admitted into evidence and published to the court, then I'll state for the record that I'm opening up that specific document in the Google Drive. We're all officers of the court, but I think it's necessary to state that for the record. Otherwise, the court can run afoul of just going in there and looking at the documents. Obviously, we're navigating a new threshold here, and so that's one way that I have been practicing it. I know that well, that's how I've done it so far. I don't know if Judge Alvarez has done it by another means or Judge Diaz has done it by another means, but using that Google Drive seems to be a little bit easier than having to sort through emails and find emails, because at the same time I'm getting all kinds of other emails that are coming in from an administrative perspective or from other court settings or my clerks, and so I'm having to navigate emails to find your exhibits, and so I want to deal with all of that, and that's why I set up the Google Drive. So in practice, you would have all the documents in Google Drive. You would previously had tendered it to your client for review, represent to the court that the same document that your client is reviewing is sitting in the Google Drive. Opposing counsel will have the right to access it in Google Drive just as they would if they were sitting in the courtroom and asked to review the document. After you've done your prove up and it's either not objected to or it makes it into evidence, then at that time you can ask to have it published to the court, and then I'll represent to you on the record that I'm opening up that document, and that document is named XYZ sitting inside the Google Drive. I'll open it up and then I can review it at that time. And then what I'm doing is following that, all the documents that have been admitted, I'm moving to another folder that is admitted exhibits, and then those that are not admitted, I'm shifting to a folder that's not admitted. At the end of the hearing, just as we would do in regular court, I'm asking if you want to withdraw your exhibits. If you choose to withdraw your exhibits, you can go in there and withdraw them. And I ask that you do that before we recess the hearing, so everybody goes into it, they withdraw them out. Or if you want them retained in the record, then they stay in the record. I kind of, before the hearing is over, I cut access off to you guys, and then it stays in the record, and then I can give them to my court reporter. That's how I'm doing it. I know Judge Villarreal in Webb County is doing it that way. That seems to be working for me. Judge Diaz, Judge Alvarez, do you have a different way of doing that?
I think
that answer your question, Ida?
I think I'm more interested in adverse witnesses, respondent, when I'm cross-examining or doing something like that. Does that same rule apply?
So in that situation, I saw that yesterday in a hearing, and so what we did is the adverse witness had an email box available to them, their email. Opposing counsel emailed to them the document that they were requesting they review. They were reviewing it, and then that's how they did it. It's in representation with the Google Drive. Okay. So, Judge Alvarez, did you have any?
And it may be that you send a private message to that adverse witness with the document attached and have them review it once you get permission from the court to do that. Like I said, I haven't set up the Google Drive. I'm still trying to learn how to do that and work through that. I've seen the presentation, and Judge Alvarado has graciously agreed to help me at some point, but my court reporter wants hard copies after the hearing. I think she's going to be working remotely, and there may be some tech issues and some printing issues. And then ultimately, I think, and I agree that it's the duty of the litigants to make sure that she has the exhibits. That's your evidence, and you've got to attach it to the record. I am going to ask that the exhibits be shared ahead of time, because I want to make sure that what's admitted and what's presented hard copy matches, right? So what was shared before the hearing, what was on the record admitted, is what actually gets attached to the court official record, because that's going to be coming in through the hard copy. So again, it may change as we get more hearings under our belt and go forward, and what's cumbersome and what's not. And again, these are in situations where the exhibits are not withdrawn after the hearing. So keep that in mind. I do see some hands up, Ms. Mazahari and then Ms. Reuter. Oh, I'm gonna unmute you. Okay.
How do we handle time announcements? If my time announcement in presiding would be 2 hours without dealing with technical issues, then I would announce 2 hours, but it's gonna take me a while to get around this. So what are your expectations as far as time announcements are concerned?
I think, given your practice and given the skill set and given what you know about yourself and opposing counsel, and once include that conversation in your conference. But I think there's going to be some grace, right? There's going to be some leeway. But if your 2-hour announcement turns into a 6-hour announcement, that's going to be problematic for the presiding court. Like, we appreciate that it's going to take longer, and we appreciate that there's going to be a learning curve, but we still have cases that we're trying to process through presiding court. And so if ordinarily it would take you 2 hours, I don't know, maybe add another 30 minutes or another hour, but that's a conversation that you're going to have on a case-by-case basis, depending on how exhibit intensive that case is, and depending on how many agreements you and opposing counsel have reached. But I will say, everybody appreciates that there's a learning curve here, and everybody appreciates that a Zoom hearing is going to take a little bit longer than a live hearing. But we still have to be mindful of the presiding court and of our system and of the cases that will be waiting behind you, still waiting to get out. So I guess we're all just going to be doing our best. Ms. Reuter? Oh, and I'm sorry, you started off as muted. Are you?
Yes, am I unmuted now?
Yes.
Okay. So if I have to subpoena a witness, should I assume that I'm just not going to be able to have a hearing? Or are you guys, and that's based on what Crystal and Judge Miskell had said on Friday.
Right, and then just to recap that conversation for the folks here, I think Judge Miskell and Judge Ferguson agreed with this position, that there is really virtually no way to hold someone in contempt for not appearing. And I think that's something that we're all thinking through and trying to struggle with. How do we subpoena the witness that doesn't want to show up, the reluctant witness, the adverse witness? Where do we have them go? To a lawyer's office, to the courthouse, to a virtual meeting ID, website, basically. And there's just going to be very little room for us to enforce that or force that by contempt. And maybe some of those hearings are going to have to be reset. Maybe you'll find a way to get the evidence or have the logical conclusions reached based on the witnesses that are present. But I I don't disagree with what they stated on the family law section training video. I don't see how you can get a capias issued on a virtual appearance.
If we have somebody, and I'm sorry if I can follow up, if we have somebody like CPS or somebody that we know we have to subpoena, but generally they'll call and talk to us, where do we tell them to go on the subpoena for that?
There is going to be a Zoom meeting for presiding court. Maybe you tell them to go there. Maybe you tell them to be on standby and you forward the email that you receive from the judge that's going to be hosting your particular hearing. Again, I hate to sound like a broken record, but the logistics of that are going to be on a case-by-case basis and based on the relationship that you have with that agency witness, right? Whether or not, and honestly, whether or not they're going to have the flexibility, because they're on skeleton crew now too, and they're on essential, work home, work safe orders too, at least here in Bexar County. So I think it'll just be on a case-by-case basis. To me, the cleanest way would be to have them on call. And once you get the email from the judge that's going to be presiding over your case, forward them that email so they can click on the link and join in on the hearing.
Okay.
That's just what I think, on the fly right now. Ms. Hesbrook?
Yes, can you hear me?
Yes.
I had to move to a different device. So my question is, there's a couple of hearings that I've gotten notices for next week. And unfortunately, I don't think that they're really exigent hearings. Is that still a requirement? I mean, if we're going through all of this, does it have to be something that is of an emergency nature or of a, does it, for example, temporary orders, does it have to be where there's an affidavit where there's harm, or these are all just the new way of doing these temporary orders hearings?
No, I think, and correct me if I'm misstating this, but I think given our operation procedures, beginning on April 6th, we're hearing cases remotely, essential and non-essential. The essential cases will be given priority. So maybe your non-essential case may not be reached. Maybe your 2-hour announcement on a non-essential hearing will become a 1-hour announcement and just, narrow, short, this is all the time that we have to give this non-essential hearing. But I do know that the dockets are capped. I do know that there's a recognition that there's going to be a learning curve and these hearings are going to take a little bit longer. And if it's non-essential and if it's something that can wait, maybe, again, just like when we're in presiding and the dockets are not capped and we're trying to get through, 289 cases in a day, maybe it's something that you reset by agreement with opposing counsel. Or I know there are mediators that are doing Zoom conferencing as well. Maybe it's a case, if it's a non-essential case, maybe it's one that lends itself to mediation.
Just a quick follow-up on that. So we're going to be in this YouTube meeting in presiding where they're calling all the cases, and then we're just going to wait until we hear whether our case was assigned. Is that accurate?
That's accurate, with the caveat that we're going to try to get you out as quickly as possible. I mean, that's always been our goal, right, as the judiciary serving y'all. And Judge Poza is working with Judge Alvarado and Judge Diaz and really trying to make sure that it gets as streamlined as possible. So cases get sent out, the time announcements are observed, and the next round of cases get sent out. So, but yes, there will be a YouTube channel with presiding court, the docket will be called, and the assignments will be made just like they are live, but it'll be virtual.
So if I can make a suggestion to you all, because I've been working with Judge Poza on this, and she's going to be presiding beginning next week. And my understanding from her of how she's intending to do this is that she will have the YouTube streaming from a Zoom presiding docket call. However, I don't believe that she's going to be asking for announcements initially until we get used to this. That's why it's important that in your notices, you do a time announcement. I think constructively, she's going to be calling the docket. She's going to do a set of initial assignments that are going to go out, and they will be emailed to each of us judges that are assisting presiding. And then it is our responsibility to generate the Zoom link and access code, and either each of us personally or our district clerk that's assisting there with us will be reaching out to you by way of your email and giving you that information. They'll also be contacting you on the phone, same thing for unrepresented litigants. As a matter of course, if you're going to be dropping your settings, you need to contact presiding court at the 2610 phone number. If you come to agreements while you're waiting for an assignment, you need to notify presiding court of that. So that way Judge Posa can shift those slips over and just focus on the ones that are waiting in line for an assignment. I think once she gets used to this process, because we all are getting used to this process, she may change those or modify those, but in my discussions with her at this point, that appears to me what I think her plan is. Obviously that could change between now and Monday. But I'm anticipating that the initial call of the docket, she won't be asking folks to give an announcement through Zoom. I think she's going to call the docket as a matter of form. She'll make some initial assignments based off of, I think, the order and the time announcements that have been provided. And then at that point, it'll be just a rolling assignment with the judges right now. We're going to ask for your patience on this. I mean, in a matter of a week and a half to 2 weeks now, we have all had to get up to speed on trying to wrap our minds around these government mandates that are like a moving target and change every 2 to 3 days. Trying to develop a plan that's going to get our access to justice back online, navigating a new software program called Zoom, and trying to figure out all the kinks and the pitfalls of using it, and then trying to have good communication with our bar. So it's been an effort, and we are meeting day in, day out, constantly trying to adjust what our plan is going to be for Monday. And so I anticipate by tomorrow, you're probably also going to have an amended plan that will be rolling out that we've been working on and still tweaking from the one that we issued. I think, was it on Tuesday or Thursday of last week or Friday of last week that we had issued. It's not going to be a lot of changes. It's just more tweaking and refining more than anything. So I hope that answers your question with how presiding is going to be looking right now. So again, patience is going to be a big request on your part.
Thank you. Are there any other questions? I saw the questions in the chat from Ms. Day regarding the child support court and the county courts. I don't have any information about that. I can assure you, I'm sure they're working just as hard as the 14 of us are trying to come up with their operations plan and moving forward. And if I get that information, I plan to do these daily this week, just as we all work together to get up to speed for the remote hearings. If I get that information for the folks here practicing in Bexar County, I will share that. Are there any other questions?
Judge, can you hear me? This is Lisa Duke.
Yes, ma'am.
Okay, real quick, I have a special setting that is set. It was referred to a judge, and then we ended up moving it about a month out, which is going to be on April 12th. That is supposed to be a 3 to 4 day hearing. But with all of this going on, and the sheer amount, I mean, phone books of exhibits, I'm wondering, is that even going to be a possibility, or should I kind of just try to, maybe let my client know that this is something that will likely be moved because there's not, I'm wondering, since I was wondering if there were even any special settings going forward at this point, much less mine that is this long.
Is this a special setting that you had set through monitoring, or has already been specially set with a judge?
It's kind of weird. What happened was we went to court on March 13th with the 3 to 4 day announcement, and we got assigned. And then in the interim between going to that judge, the opposing party said that she did not feel comfortable going forward with the current virus and everything. So Judge Jimenez told us to go ahead and keep going to go to that judge and get a reset, but to go ahead and stick with that judge. So
then my recommendation is going to be, you need to contact that particular court and find out how they want to proceed. Just by way of an example, I know Judge Jimenez has had an extremely lengthy hearing that she was assigned at, I think from Friday of last week, and it's carried over so far to today. I don't know if she completed it or not. So I know that we're able to manage long hearings, and I anticipate we're going to get some of those kind of settings out of monitoring now that we don't have jury trials, but we may still have those lengthy bench trials. So it's really going to go, Lisa, to your preparedness and how you mark your documents and if you've got them all scanned into the system. But certainly I would suggest maybe talking to opposing counsel, reaching out to that judge that the case got assigned to, perhaps ask for a pretrial discussion, not to discuss the facts of the case, but just the simple procedural of how are we going to do this, and what is your preference, so we can prepare our exhibits accordingly to present this hearing to you. That would be my suggestion, since you have that specially set already. But,
okay. Oh, I'm sorry, Judge. Go ahead.
It's okay. I mean, each of us had a bunch of special settings that were on our docket. And initially, those that came through the essential time frame, which was, now until April 6th, many of us went through and did a lot of resets on those that were non-essential, and then continue to handle those essential ones. Some of them needed to get orders in. Some of us did handle just a few of those motions to enter that we maybe already had on the docket, but not very many of us did that. But I think at this point in time, since April 6th going forward is both essentials and non-essentials, and if you do have special settings, I would highly suggest reaching out to that specific court that you have the special setting with, just to make sure that the case is still scheduled, and also to find out what their specific protocols may be with respect to using the Zoom function.
Okay, thanks, Judge. And I'll also check with my opposing to see if he is going to say he's not ready given those circumstances. One other real quick question, which I may have missed last week. If something is already set, is it going forward, or do you have to do a new motion to set on it?
For April 6th?
Yeah, I have, like, for instance, I have a trial that was set by opposing counsel for April 20th. And I'm wondering, is that still going forward without one of us having to resend a new notice? Or, I mean, are we still on the docket?
Well, we are going to be publishing fairly soon certain requirements with respect to notice. So I think out of abundance of caution, if you have something that's already set, but maybe your notice doesn't have specifics that we're going to be publishing here pretty soon, I would just reissue the notice. But it would just be an amended notice with the new requirements. I wouldn't necessarily, and I think that would satisfy the requirements with respect to the line items of what you're supposed to have in your notice. Judge Alvarez, any thoughts on that?
I think you are still set on the docket. I do think that the staff attorney's office will be reaching out to you to get more information, and I think they would really appreciate if you could be proactive and provide that information to them. I know it's taking a lot of time to get information like email addresses, etc. So if you have that and you know you can provide that, I would reach out to the staff attorney's office, carbon copy your opposing counsel, and make sure that the notice, that they have the information that the new notice requirements are requesting.
Okay, and so everything that we send to the staff attorney's office is going to be that civil intern one at Bear or whatever. Is that right?
I think that's the one that they're using for things coming in and out of presiding court. Is that, I think.
The civil intern one, if I remember from the notice, I don't have it up in front of me, but I thought that was for the default judgments. It could also be for the staff counsel. I don't have it in front of me. I would have to go dig for it, but I know which one you're referring to.
Okay, yeah, that was the one that you send your agreed orders to. I didn't know if that was just the general one we go ahead and send them the notices to, or.
That's a good point. Are you having another session, Judge Alvarez, tomorrow?
We are. We're having another session tomorrow at 5. So
before I answer that, Lisa, let me make sure that I verify with our respective departments that we're working with. That's where you should get those to. That's why I had mentioned maybe just doing an amended notice or a supplemental notice, just to indicate that additional extra information with email addresses.
Okay.
But I'll check on that for you. And then if I'm not on tomorrow, Judge Alvarez, maybe you can share that information, okay?
Thank you all so much.
yes, absolutely. It's right after 6 o'clock. I don't want to keep anyone. Again, we're going to do this tomorrow and Friday, but are there any questions now?
Can you hear me?
Yes.
This is Shanti. I've got one quick question. We've been mailing in agreed orders per the instructions before now. I don't know, the days all blur. Do you know what's happening with those? What's happening with those?
They are, yeah, go ahead, Judge Alvarado, and then I'll put in my 2 cents.
You have to understand something. There's been a lot of disruption, not only amongst the judiciary, but we've had disruption within the district clerk's office, within the staff counsel's office. And so, for instance, there's skeleton crews running right now. So they're behind on citations. The staff attorney's office, they are inundated and backed up. So yeah, they're receiving those orders, and I understand Judge Chapa in presiding and some of our other judges are taking those orders and going through them and signing them. If they were emailed, if I recall correctly from our operations plan, if they were emailed, you weren't going to be getting a conformed copy back. If you mailed them in, then you would get your conformed copy back when they were signed. But you have to be patient on that because there is a backlog right now. And so I wish I could say we're going to be able to get those turned around right away, but this is a lot of departments working together, not just the judges. And you have to remember a lot of our staff, like our clerks, we are not their direct supervisors. They have supervisors, which is the district clerk. And so there's a lot of interdepartmental workings that goes on there, okay?
That is perfect, and I will pass that on to my clients. That's a great answer. Thank you so much.
Yes, thank you. All right. Is there anything else that we should cover now, or is there anything that's confused? Well, I have lots of things that are confusing, but is there anything that we can answer now and then give y'all time back so you can get back to your families or your work or other things?
Question about the assignments. If we're not going to know till that morning, and each judge is using a different method, somebody's using Google, somebody's using Dropbox. I guess we have to set all those 3 up now. Is that what my understanding? Because we don't know which judge is going to want which method of information to receive, I guess, and what method to receive it by.
And it sounds really confusing, I know. But I think the best practice, regardless of which method is being received, and we're working hard together to try to minimize disruption. But if you have what you need, your live pleadings, your exhibits, either with you handy to where you can just send it out, whether it be by email or by Dropbox, or if you have an assistant at your office, if, you know, turn one of the high school students that are not at school right now. No, I'm just kidding. But if you have that handy, if you have that prepared PDF style ready to go, then whether it's an email or whether it's a PDF or a Dropbox link, you're ready to send that out. That probably doesn't give a lot of assurance, but we will do our best to try to streamline everything. Just like the bar has a technical learning curve, so do we. I mean, we're part of the bar. We're really learning this and learning the functions and learning the best practices as we go, just as you are. But I think if you've got the PDFs ready to go, if you've emailed yourself everything that you would either email to the court or drop in a Google Drive, then you've got that handy and you'll be ready to do it. And if you're not, and you need some time and you need a few, 5-10 minutes on your assignment to get that situated, I'm comfortable saying that the judiciary is going to work with you as much as we possibly can, because that's what we expect as well, right? We're trying to all give each other some room to grow and to get up the learning curve. And I see Miss Mazahari and Miss Hesbrook and Miss Gutierrez. I'm sorry for the non-answer, but hopefully it was helpful and assuring a little bit. Oh, Miss Mazahari?
If we're going to have somebody help us our first couple of meetings with technical issues, like my younger staff are tech savvy, do we announce on the record that my assistant is here to help me not embarrass myself when I'm trying to do a Zoom hearing? How do we handle that? Because there's no way I'm going to sit here by myself at my first hearing. Somebody's going to have to hold my hand. I volunteer Shanti Day.
Yeah.
Cut that out,
I don't think you can go wrong with candor. I don't think you can go wrong with transparency. And I don't think there's any objection to having your legal assistant, be it in the form of a friend or your legal assistant, assist you in the presentation of your case. That there wouldn't be a basis for objection if we were all in the courtroom together. I don't see a reason to have a basis for objection in the virtual courtroom. But I don't think you can go wrong with candor.
Even your high schooler, even your high school kid that is tech savvy? Okay.
Right. I wish I had one. I've got a decade or so before I can have one of those, but yes, even them.
They know it all,
They really do.
I'm being facetious.
Go ahead, I'm sorry.
No, go ahead. I said I'm being facetious, but they think they know it all, yeah.
I'm dealing with it right now at home. With respect to assistance, also, one of the things that I saw during the mock trials that we've been trying to conduct and learn from was when you have, two attorneys, co-counsel, and they're sitting in separate offices. One's designated as a lead, and then the other one is designated as the manipulator of all the exhibits. So I've seen that happen too. I don't necessarily think that if your legal assistant is sitting at home and they're able to do all that as well, and they're not necessarily in the office with you, I don't have a problem with that either. I mean, they would have been allowed to come into the courtroom anyway to help you, and a lot of you do bring in your own legal assistants and your clerks to assist. So how is it any different? And that's the way that I look at it. As long as, like Judge Alvarez says, that you're candid about it, I'm fine with that.
Great.
All right. Any closing thoughts? I see that Judge Diaz has put some notes in the chat.
Hi, judges. This is Maribel Cruz, and I'm asking about how we know what emails we need to send links for, drop boxes or sharing our exhibits with the courts themselves. I see that Judge Diaz is talking about ensuring emails are updated on the county site. And I know, or at least the last time I looked at the county site, most of the clerks' emails are up there. Not all of the judges' email. Oh, I don't know that any of the judges' emails are on there. And I didn't think that the clerks are really available to be able to utilize Dropbox. So can you speak to any of those issues?
Can I speak to that real quick? I'm sorry, Judge, and that was a question for Judge Diaz, wasn't it?
Go ahead.
No, it's actually for everybody.
Yeah.
Well, the assignment is going to be emailed to the judges and their clerks. Just like I don't know what's going to come up from presiding, the morning of. It's going to be the same process. We're going to be on standby watching our emails, and that email is going to come up with the assignment. At that point in time, either the judge or the clerk, depending on the custom of that judge, is going to reach out to the attorneys. And so your email addresses will have been in that assignment that we received, because our notices now are requiring that you put those email addresses there. So those email addresses will be there. They'll be sent to us, and then it is our job to turn around and email to you with those email addresses that you provided the instructions. And so the instructions will be, this is your Zoom sign in. If we have a Dropbox link that's set up, it should have the Dropbox link that's there. If we have a Google Share Drive, I will be sharing to you that link to Google Share Drive. So if you have a Gmail account, you have a Google Share Drive. It's not like you have to go set up a separate account unless you want to set one up specifically for your law firm. So you'll have it there, or you'll have instructions about getting email. So each judge is going to notify you when that assignment takes place. All you need to do is have your pleadings and your exhibits on your computer somewhere. So it's literally a drag and drop into a Google Share Drive, or a drag and drop into a Dropbox, or an email upload. Obviously, some documents are not going to get emailed because of size. And that's one of the reasons I'm using a Google Share Drive as opposed to email, because you might hit the county firewall, and you said that you sent them to me, but I never got them because they got stuck at the county firewall. That's another reason why I'm deciding to use the share drive as opposed to doing it the email route. So I hope that answers your question, Maribel, with respect to the directives and knowing where to send exhibits. You all amongst each other have a duty to share those ahead of time based off of our operations plan. But you won't share them with the court until you get your assignment and then that judge's preferences on how those will be shared.
Yes, that did answer the question. I'm just wondering if your process is going to be the same across the board, or if it's going to change by judge to judge.
We are trying to be uniform. You have to understand that with respect to the 14 of us, we have those that are like super duper tech savvy. I'm going to use Judge Diaz as an example, because she's like a whiz when it comes to tech. And then you have others on the other end of the spectrum that, maybe know how to open a Word document, but when it comes to other stuff, it's a little bit more difficult. So we have a learning curve right now amongst the 14 of us. I would like to say I'm somewhere kind of in the middle. And so getting everybody adjusted to learning what a share drive is. So for instance, Judge Diaz knows what a share drive is, but maybe Judge so-and-so on the other end of the spectrum has no idea what a share drive is, and they're just learning that stuff right now. So we're trying really hard across the board to bring all of our judiciary up to speed on this. And so as much as I'd like to say that it's going to be uniform across the board, it may not be initially until we get everybody up to a level of that learning curve, and then they understand, okay, this is how it's going to work. We're working with our court clerks, but even in that regard, some of our court clerks aren't even as tech savvy as others. So I wish I could say yes, and that is our goal, is to be uniform across the board and come up with a best practices. But basically, we're taking the well-oiled machine of presiding and from the tangible format of in person, and we're having to thrust that in a matter of 2 weeks time period into a virtual world, and that's been an effort. So that's the best answer I can give you. I don't know if Judge Diaz or Judge Alvarez has anything else to add to that.
My only addition is that no matter what the method is that we're going to be needing to receive the exhibits, you're going to need to have them ready to go. And that means that you're going to, I recommend if it's voluminous, that you consider figuring out how to put them in a zip drive in a folder where it's just ready to either be emailed as a zip drive or be dropped into a Dropbox link or a Google Drive link that is sent to you from a court. So from your end, I think, yes, there is some uniformity in that everyone needs to have it together in one place as best as possible in a way that is very easy to just drop into something or to email. I've been getting pleadings right now in the limited hearings that I've done that are they're just emailed to me as separate attachments, and it becomes pretty messy. I have to download them all and make sure I've got them all in one place, and it's kind of messy. So if you can just on your end put everything in one place in a zip drive or in one folder that you're going to email or drop to us, that's the best advice I can give you for now.
And don't worry if you don't know how to do that. We are going to learn together. Ms. Mazahari, I see your hands up. Do you have a new question, or did I just not lower it from last time?
Either you didn't lower it or I accidentally raised it without realizing it.
Okay. All right, y'all. Well, we're at 6:20. Thank you all so much. Judge Diaz, Judge Alvarado, Judge Flores, thank you for joining us as well and helping us share this information and get us all up to speed. If you want to be invited tomorrow, if I could trouble you to send me an email, because that's, again, low-key, tech-savvy, barely in the middle. I'm just forwarding the invite to everyone that I can think of, and I'm asking you to help me get the word out and share with your colleagues who may benefit from this. And we will definitely make the virtual courtroom a skill set that we have under our belts together. So if you'd like to be invited tomorrow, please email me. If you don't feel it's an obligation, you don't have to be here, but if it's helpful and if it's helpful to anyone that you know, please share and help us get the word out, and we will definitely learn this virtual courtroom together. All right. Thank you all so much. Thank you. I'm going to end the meeting now, and again, thank you for being here, and thanks for helping us to keep things moving.
Thank you.
Thanks.
Right. Bye-bye.
Bye.
Thank you. Bye.